In this topic, we're going to cover administrative law. So the third function of an administrative agency is conducting investigation. There are some statutes that Congress has given administrative agencies the responsibility of oversight, of making sure that companies or persons are complying with the statute. Um, it, Under this, this includes many things. Could include the agency going in and conducting interviews with people. It could include them going in and subpoenaing and reviewing records. It could also include them showing up and performing a search. An example that comes to mind is OSHA. OSHA is tasked with ensuring that workplaces are safe for the workers. And so OSHA gives, or the statutes give OSHA the authority to inspect workplaces to ensure that the employers are complying with the minimum safety requirements. If OSHA finds that there's a violation, then OSHA has the authority, just like the second bullet point says, they have the authority to come in and seek civil penalties and or seek criminal penalties through a lawsuit. So that's where the administrative agency is tasked with making sure that employers are complying with the requirements and regulations of OSHA. So the last function of an administrative agency is taking informal discretionary action. This is kind of a catch-all category. Administrative agencies do many things, and this is what's considered discretionary action. And so these are the small matters that again help avoid courts or someone else having to deal with it. And so examples of these is deciding who to award a loan or a contract to, resolving tax disputes informally for the IRS, and determining and administering Social Security plans, deciding whether to grant a license or a lease or a permit. Like I said earlier, the DEA has the authority to decide which doctor should be given a registration to allow them to write controlled substances. That's an example of an informal discretionary action. They have authority as the administrative agency to make some of these decisions and to handle some of these tasks. In the informal discretionary action, there's very little formal rules and procedures that's set forth for the agency to follow. As you can probably imagine, sometimes you may get what would be considered a quick resolution, but at other times, and I think this is what most people would feel, is that you may feel like you're going through an endless maze of decisions and appeals of trying to get something accomplished or done. So the interesting question with these administrative agencies is you've just heard about them and the four functions that they primarily handle. Well, of those, last week, or in the constitutional law section earlier this week, we talked about the U.S. Constitution provides for three branches of government: the legislative, the executive, and the judicial. It didn't say anything about us having an administrative agency branch. And administrative agencies, like we just talked about, they cover both legislative and a judicial type function. In a legislative, they make the regulations that help supplement the statutes. But they also make what could be considered judicial decisions because they're allowed to make formal adjudications. So is a delegation of both legislative and judicial power to these administrative agencies constitutional? The Supreme Court has held yes. There have been a couple of times where they've maybe invalidated, but it's been from the early 1930s where they've invalidated some functions that have been given to administrative agencies. But primarily, the U.S. Supreme Court has upheld the power of administrative agencies to function and to perform the tasks that they do. So earlier when we talked about the deference that's given to these regulations, I mentioned Chevron deference. And Chevron refers to the U.S. Supreme Court case in which the U.S. Supreme Court articulated a two-phase inquiry to determine whether an administrative agency's interpretation should be considered as being appropriate. And so when we say interpretation, that's referring to usually like some sort of regulation in which they articulate their interpretation of the statute. So there's the two-phase inquiry. First, the courts consider, did Congress address the issue directly in the statute? If Congress directly addressed it, then there's no need for the administrative agency to provide their guidance on it. The inquiry stops there, and what's stated in the statute is what's followed, not what's stated in the regulation. But if the statute is either silent or the statute is ambiguous, then the court goes on to examine whether agency's interpretation was based on a permissible construction of the statute. And so if it's based on a permissible construction of the statute, then there's going to be deference given to the regulation. So this permissible construction of the statute really turns on whether they find that the agency's regulation is reasonable or rational. If it's reasonable or rational, the court will defer to the agency's interpretation. So in the examples that we talked about where maybe the action is invalidated, it would be invalidated perhaps because it's inconsistent with what the statute says. If the regulation is found to be inconsistent with what the statute says, then obviously the interpretation is not reasonable or rational. A way to help determine if an agency's regulation is reasonable or rational, you consider the age of the interpretation, the age of the regulation, and whether there was any congressional action or the lack thereof in response to that regulation. So the age of the interpretation, if Congress was aware of the regulation and they've either act or they failed to act, then it's presumed that Congress is approving of that regulation. If Congress did not approve of the regulation, or in other words, the administrative agency's interpretation of the statute, then you would have expected that Congress would have amended the statute to contradict or to reject the regulation because the statute would trump the regulation. But by Congress not acting, the inference is that Congress is presumed to approve of the agency's interpretation. So judicial deference through the Chevron process is limited to administrative interpretations, regulations that have happened through the formal proceedings with the force of law. So this includes adjudications and regulations that are promulgated through the formal rulemaking process that we talked about earlier. When it's put out for public comment, if a regulation goes through that and is adopted, that's going to be one in which judicial deference would be given to. But if it is simply an opinion letter written by an administrative agency to a particular person in response to a particular set of facts, that's not going to be entitled to deference. Same thing, if a administrative agency has put out some policy statement about what they intend to accomplish with a regulation, that's not going to be entitled to deference. Nor is any internal agency manual that may be out there. Any administrative manual is not going to be entitled to deference because that's something that's been just drafted internally and not gone through a formal rulemaking process, but it's just there given by the administrative agency itself without any comment and rulemaking period. So we talked about these informal discretionary acts that were done. On the informal discretionary acts, if they're challenged, courts will often affirm the act as long as it's not arbitrary and capricious. That is, as long as it has a rational basis, the court's going to consider the action as being valid. So it's harder to invalidate some informal discretionary act as opposed to a formal adjudication. Standing. We talked briefly about standing last week. when we went through the litigation process. Standing is a principle that applies, that limits a case or controversy before an administrative agency. So in order to seek judicial review of an agency action, the plaintiff is required to have standing. So there are three main requirements to have standing. First, the plaintiff has to have suffered an injury that's concrete and particularized and actual or imminent. It can't be some conjectural or hypothetical injury. So in other words, the issue has to be real. You can't have a hypothetical injury. For example, if you have a doctor who has a license, but a new regulation is promulgated that may be applied to that doctor and take away his license. Well, it hasn't been applied to him yet. So any claim that he may have is not concrete and particularized. It's not actual or imminent. It's just a hypothetical type injury that may exist. Second, the injury must be fairly traceable to the alleged action. So if the agency did decide to apply that rule, new regulation to that doctor, then that injury would be traceable to the action. If he's challenging the validity of the new regulation or the decision to apply it to him retroactively, the injury would be traceable to that action. Then lastly, it must be likely that judicial action will redress the injury, that it will provide some relief through a judicial decision. And if in that instance, there would be relief if it was being applied to him, because the court could issue an order saying that it doesn't apply to him, or that he's exempt from it, or that the regulation exceeds the authority. Whatever relief that they may offer, it's likely that it would correct the injury that has happened, which would be his inability to work. If you go through any of this and one of these three is not met, then the plaintiff would lack standing. Without standing, the claim would be dismissed. Exhaustion of administrative remedies. This is another doctrine that limits the cases that the court has to review. So we talked about earlier that to get to the court for review, you have to have a final agency action. And so this exhaustion of administrative remedies goes to that principle. So before a court will review an agency action, the administrative agency process must be completed. That means you've got to pursue all avenues of relief. If you go before one person and they issue a decision, but you have the right to appeal to a board of, say, 3 agency members to make a final determination, if you don't appeal to that agency board, then you would be precluded from seeking judicial review, because in the eyes of the court system, you will have not exhausted your administrative remedies. You will have not done all that you could to reach a final agency decision. So now courts do have the discretion to waive this requirement, and sometimes they do. That's very limited in my experience, because typically if courts have an out of a lawsuit, they'll usually take it and dismiss it when they can. It's also possible that the agency would waive the exhaustion of administrative remedies process if they did not raise it as a defense. So if the agency let it go, the court is likely not to dismiss it on its own. Issue exhaustion, this goes back to our discussion about the review in a court being limited to the judicial record. So you're in the same vein, you're limited to the issues that you raise at the administrative level. So if you've not raised an issue before the administrative agency in which you've put the testimony that you need and you've put the documents that you need in the record to support whatever your argument is, If you didn't raise that and support that below, then you're going to be precluded when you're in court to raise that issue at the court level. The agency has to be given the opportunity to consider and make a decision on the issue. If that doesn't happen, then you're generally going to have waived that issue. Ripeness is another doctrine that helps limit the cases that the court has to decide. So the courts only consider issues that are ripe for a decision. So they won't consider a hypothetical issue. Like, go back to the example that we talked about a few slides ago about a new regulation being enacted that may affect a physician's ability to have his license to prescribe controlled substances. In that instance, if there's the new regulation that comes out but it's not being applied to this physician yet, that would be a hypothetical issue. If the doctor tried to sue the agency over it in a preemptory fashion, then that would be a hypothetical issue that would arguably not be ripe for a court to resolve. So that would be what's known as a pre-enforcement challenge, because you're challenging the regulation or interpretation before the agency has actually applied that new regulation to the plaintiff. In that example, they've not applied that new regulation to the doctor yet. So if they did decide to apply it to the doctor, then your issue would be ripe for a decision. And it would remain that way as long as there's a dispute. If at some point down, if they are applying it to the doctor, but then they reach a settlement in which they agree that they won't apply it to the doctor, then the ripeness would no longer exist because there would be nothing to resolve. It would only be a hypothetical issue. In a general sense of a pre-enforcement of, does this apply to doctors like this one? But you're no longer considering that doctor because he's resolved his issue with the agency. The last topic that I'd like to cover in this section is the Freedom of Information Act. It's referred to as FOIA. FOIA is a very important statute. It's what allows individuals to obtain copies of governmental records, including agency records. There's a premise out in the legal community that the transparency with the government, and so you can argue, especially in politics, about how transparent the government is, but generally, in most senses of like the informal decision making, to the investigation, to the formal adjudications, to the rulemaking process, a lot of that is open, and you would be able to, as a citizen, request governmental records on any subject. A very common example is that I see people in employment cases, and we'll talk about this in a future week. Before we talk about administrative remedies and exhausting those, in a lot of employment discrimination cases, you have to file a claim with the EEOC before you're allowed to file a lawsuit in federal court. And in that instance, the EEOC will conduct an investigation, and they'll have it, and they'll either decide if there's merit or there's no merit to the case, to the charge. And if there's no merit, then they issue a right to sue letter, and then the plaintiff is entitled to go sue. In those examples, it's very common that when I get a lawsuit like that, one of the first things I do is I send a Freedom of Information Act request for all the documents that pertain to whoever the employee's name is, whoever the employee is, to their EEOC charge. Because you can get documents and learn information of what the employee told the EEOC investigator, because you may get notes from an interview with the employee. So you can request documents on anything, and sometimes they're helpful, sometimes there's not. And there's no limits based on you've got to give a reason why you need it, or that it's relevant to something. They don't have a basis to withhold it because they don't think it's something you need or relevant to what you're trying to do, or you didn't give them a good reason why you need it. You don't have to give one. You just request the documents and wait to receive them. The government, under the Act, generally has to respond within 20 days. However, often your response within that 20 days is a letter telling you that they need additional time to process your request, and they'll give the same. I think it's a boilerplate letter if it's an extensive request that involves a lot of records that they've got to look through, and they've got to review and locate them all. And anyway, you'll get it a few weeks later to a couple months later. There are times though where confidentiality does exist for the agency, and they can protect information by either outright withholding a document or with only redacting portions of a document. And so sometimes you'll get a response and it will contain blacked out or whited out sections.